Hello, everyone. Welcome back to our channel, U.S. Immigration News. Trump administration plans historic expansion of denaturalization efforts. Please hit like and subscribe for an upcoming video. A profound change is quietly unfolding within U.S. immigration enforcement, one that could redefine how secure American citizenship feels for millions of naturalized citizens. The Trump administration is preparing to dramatically expand denaturalization efforts, legal actions that revoke U.S. citizenship from individuals who allegedly obtain it through fraud or misrepresentation. According to internal agency guidance reviewed by the New York Times, U.S. Citizenship and Immigration Services has instructed its field offices to refer between 100 and 200 denaturalization cases every month to the Department of Justice during fiscal year 2026. If fully implemented, this plan would mark the most aggressive citizenship revocation initiative in modern American history. For the nation's roughly 26 million naturalized citizens, the policy signals a notable shift in how permanent their status may feel moving forward. Why this expansion is historically significant? To understand the gravity of this proposal, historical context is essential. From 1990 through 2017, the United States averaged only about 11 denaturalization cases per year. Even during the first Trump administration, when immigration enforcement intensified, the Justice Department pursued just over 100 denaturalization cases total between 2017 and early 2025. Now, the new USCIS guidance envisions as many as 2,400 referrals annually, representing a more than 20-fold increase compared to historical norms. By comparison, the Biden administration filed only 24 denaturalization cases throughout its tenure. In 2025 alone, the Justice Department initiated 13 cases, winning 8. This scale of escalation is unprecedented, both in volume and in its potential psychological impact on naturalized Americans. What denaturalization actually means. Denaturalization is a legal process by which the U.S. government revokes citizenship that has already been granted. Federal law permits it only under narrow circumstances, primarily when citizenship was obtained through fraud, willful misrepresentation, or the concealment of material facts during the application process. Importantly, the legal threshold is intentionally high. In a landmark 2017 Supreme Court decision, the court ruled that the government must prove not only that an applicant made a false statement, but that the statement was material, meaning it directly influenced the approval of citizenship. Trivial errors or immaterial omissions are not enough. As a result, denaturalization cases are often complex, time-consuming, and heavily scrutinized by courts, who will be prioritized under new guidance. According to Justice Department materials, enforcement efforts would focus on specific categories of individuals, including those involved in significant financial fraud, gang members and individuals linked to drug cartels, violent criminals, people who allegedly obtained citizenship unlawfully during previous administrations. A USCIS spokesperson has framed the initiative as part of a broader war on fraud, emphasizing that the agency intends to target only those who allegedly secured citizenship through illegal means. The controversy around case quotas. While advocates of stricter enforcement argue that denaturalization has long been underutilized, critics are sounding alarms, particularly over the use of monthly numerical targets. Former USCIS officials and immigration law experts warn that quota-based enforcement risks prioritizing numbers over nuance. When officers are pressured to meet monthly targets, discretion could erode. The concern is that individuals who made minor, non-material errors decades ago could face scrutiny simply to satisfy referral goals. History offers reason for caution. In other areas of immigration enforcement, numerical benchmarks have sometimes led to overreach, misapplied resources, and unintended consequences. Applied to citizenship, the highest legal status in the immigration system, the stakes are far greater. What happens if citizenship is revoked? If an individual is successfully denaturalized, they typically revert to lawful permanent resident, green card, status, assuming they held that status before becoming a citizen. However, the consequences are significant. A denaturalized individual loses the right to vote, eligibility for certain federal and state jobs, protection from deportation, the ability to sponsor family members for immigration benefits. That said, denaturalization does not automatically result in deportation. Whether removal proceedings follow depends on a person's underlying immigration history and any criminal or legal issues involved. It's also worth noting that many denaturalization cases never reach a final judgment. The government bears a heavy burden of proof, and courts closely scrutinize every claim. Naturalization in perspective. Each year, hundreds of thousands of immigrants become U.S. citizens after navigating one of the most rigorous vetting processes in the world. In 2024 alone, more than 800,000 people were sworn in, with the largest groups coming from Mexico, India, the Philippines, the Dominican Republic, and Vietnam. These individuals underwent extensive background checks, biometric screening, interviews, English proficiency testing, and civics exams. Denaturalization has remained rare since the 1990s precisely because stripping someone of citizenship raises profound constitutional and moral concerns. What naturalized citizens should know right now. At this stage, the USCIS guidance represents planned referrals, not automatic denaturalization proceedings. Every case must still pass through courts, where strict legal standards and due process protections apply. For most naturalized citizens, especially those who were truthful and thorough in their applications, the likelihood of being affected remains low. Still, awareness matters. If you have concerns about past immigration filings or discrepancies, especially those involving criminal history or prior misrepresentations, consulting an experienced immigration attorney can provide reassurance and clarity. Safeguarding the meaning of citizenship, the proposed expansion of denaturalization marks a pivotal moment in U.S. immigration policy. While targeting genuine fraud and serious criminal conduct is a legitimate government objective, the introduction of quota-driven enforcement raises important questions about proportionality, fairness, and trust. Citizenship is not merely a legal status. It is a foundational bond between an individual and a nation. Policies that unsettle that bond must be applied with restraint, precision, and respect for constitutional principles. As this initiative develops, staying informed and knowing your rights will be essential. Citizenship should never feel conditional or arbitrary. It should stand as the durable promise it has long represented. Denaturalization. Key questions answered. How common is denaturalization today? Historically, it has been extremely rare, averaging about 11 cases per year for decades. Even recent increases pale in comparison to the scale now being proposed. Does denaturalization automatically lead to deportation? No. Most individuals revert to green card status, though they lose citizenship protections. Removal depends on individual circumstances.